agents of hope, we boldly seek solutions to seemingly insurmountable challenges, matching the determination and the intensity of the medical teams that we support. In the past 10 years alone, generosity from individuals, corporate partners, and legacy gifts has contributed nearly $220 million towards bringing some of the best care to the world, best care in the world to our hospital site. Our hospital delivers services to patients facing life-threatening brain, cardiac, gastrointestinal, and neurologic conditions, to simply name a few. Through our donors, we provide our medical teams and researchers with the technology, equipment, and ongoing financial support to advance patient care, create new knowledge, and inspire breakthrough discoveries that impact health and healthcare around the world. I would now like to introduce our first guest speaker, Cathy Housdorff. Cathy is a grateful patient who wanted to give back to the hospital that saved her vision. And she also wanted to make a gift in honor of her beloved father, Stan Housdorff, who passed away last December. In leaving us a gift in her will, Cathy ensured that she and her father will never be forgotten. And she became a member of our proud Gold Leaf Society for donors who choose to leave a bequest in their will to the University Hospital Foundation. Benefits to being a Gold Leaf Society member include invitations to exclusive events, news and updates on our legacy newsletter, and a special place on our legacy donor wall. As a follow-up, we will forward you information on our Gold Leaf Society, or you can visit our website at givetouhf.ca. Cathy, we're very happy to have you with us today because your story truly captures what legacy giving is all about. And with that, the floor is yours.
Thank you, Lisa. Good afternoon, everyone. Earlier this year, I left a gift in my will to the University Hospital Foundation in honor of my father, and as a way of saying thank you to the doctors, surgeons, and staff at the University of Alberta Hospital. It was one of the most important decisions I have made in my life and the most fulfilling. Let me tell you how I got there. As you heard in Lisa's introduction, I lost my father this year. He had Lewy body dementia, the second most common form of dementia after Alzheimer's. But let me tell you, it's every bit as destructive. A once strong, proud man, my apologies, Dad was reduced to a shell of his former self, mentally and physically, before he died. But that's not how I've chosen to remember him. I remember his big booming laugh, his kindness towards others, his resilience after Mom died and finding new love again. His favorite holiday spot was Hawaii. And of course, his nickname, Stan the Man. To make his battle with dementia even more difficult, I had a serious health issue of my own to deal with as his health was deteriorating. It started with blurred vision and the loss of my periphery vision. Too many hours working on the computer, not enough sleep, I told myself. I was wrong. After a series of tests, my doctor told me I had a brain tumor. It was benign, thank goodness, but the tumor was on my pituitary gland and pressing on my optic nerves. If it continued to grow, I would have lost my vision. I was scheduled for brain surgery. I don't know how anyone else would react, but I was terrified. I felt a sense of vulnerability that I had never known before, and it was unnerving. And I was unable to have the loving support of my father, as he was too confused to understand what was happening to me. Looking back, I can now see that I was in the right place at the right time, and that the care I received could not have been better. I am still overwhelmed with gratitude for the medical teams that worked so hard to save my vision. I endured not one but 2 brain surgeries, and finally, in September of 2019, the procedure that we believe has taken care of the tumor once and for all. Between the passing of my father and my own health scare, I began thinking about how I wanted to be remembered. I've worked hard all my life and I'm proud of what I've accomplished. But I've always wanted to do more, to make a difference, and to leave a legacy of my own. Where better to do that than with an organization that has a long history of connecting support from everyday people like me to health-related causes that literally save lives. In fact, I was one of the first 500 patients to receive gamma knife laser surgery, an incision-free procedure that I had in the morning and was home in time for dinner later that evening. Thanks to the unwavering commitment of Dr. Aronyk and countless others in bringing this technology to Edmonton, the Gamma Knife procedure meant I won't have to go through another invasive neurosurgery. And it appears to have worked. My vision is completely restored and the tumor has actually shrunk. Even more amazing, donors have contributed more than $17 million to create the world-class Scott and Brown Family's Advanced Imaging and Gamma Knife Center at the University of Alberta Hospital. And from what I understand, that's just the tip of the iceberg as far as state-of-the-art equipment and technology that community support has contributed to over the years. So the decision was practically made for me. By leaving a gift in my will to the University Hospital Foundation, I am leaving a legacy for Dad and myself and contributing to the greater good of the community that I have called home for decades. I've also learned right now at the University of Alberta Hospital, one of Canada's most prominent researchers in the field of Alzheimer's disease, Dr. Jack Jamondas, is moving closer to developing a way to restore memory in the minds of people living with that horrible disease. The gift I left in my will is going to help keep that research moving in the right direction. I am still heartbroken when I think about Dad. Then I think about other families who will possibly get many more years of memories with their loved ones that we didn't get with our Stanley. Honoring Dad with a legacy gift means that a part of him will always be here, supporting the people who helped save my vision, and that makes me happy. It is now my honor to introduce my doctor and one of the doctors who saved my vision, Dr. Cathy Housdorff. As a brain surgeon, Dr. Aronyk is responsible for saving and changing the lives of thousands of people facing devastating brain conditions. As the head of neurosciences at the University of Alberta Hospital, he oversaw the advancement of brain care in Edmonton from good to great. And he has mentored some of the finest brain surgeons and neurologists in North America. Today, Dr. Aronyk works tirelessly in the Scott and Brown Family's Advanced Imaging and Gamma Knife Center, performing incision-free gamma knife radiosurgery on hundreds of grateful patients like me. Thank you, Dr. Aronyk, and like everyone else who has joined us this afternoon, I cannot wait for your presentation. Over to you.
Well, thank you so much, Cathy. I too am excited to be participating in this seminar. And I'm going to outline just one area where the University Hospital Foundation, its donors and supporters have really had an enormous impact. And that's on our ability to provide the most advanced care for the brain and the spine and all the nerves. Medical science has learned so much about so many other organ systems, but the brain is complex, still somewhat mystifying. And it's the very essence of our humanity and one of the last frontiers in our understanding of the human body. Now, I have to say that we do very well within our publicly funded healthcare system, but what I'm going to show you today goes beyond that. That's a standard level of care. We're beyond that. With the support of our community, we now have what it takes to be among the best brain programs anywhere in the world. Now I'm just having a little trouble advancing the slide. So I'm going to start it over again and see if we can. There we go. Well, it was some 20 years ago that we developed a vision, a set of priorities or key elements. And we wanted to develop a state-of-the-art neuroscience center. We called it the Brain Center. Those key elements started with imaging. We needed advanced brain imaging so that we could see the intricate details of the brain, even see how the brain worked with functional MRIs. We wanted to take that imaging and translate that to minimally invasive surgery. We didn't want to have to open large areas of the skull to look for lesions in the brain. We wanted precision, open small areas, maybe not even open the skull at all, so that we could get to targets deep within the brain. Radiosurgery programs, that's non-invasive, using radioactive elements and high energy beams to be able to treat lesions deep within the brain. We wanted to advance the stroke care. We knew the stroke was such a common cause of death and disability in Canada. We had to make progress to get people to hospital faster, start their blood thinners and clot busters sooner. We needed to have intensive care units for the brain, for the spinal cord, and for the peripheral nerve conditions. And we needed a neuroscience research and innovation program. We needed to continue to support these research and innovation initiatives to guide and sustain all of these new programs. Now, I'm going to start it again because and we'll do it one more time. There we go. It was with the inspiration and support of the University Hospital Foundation, and we're steadily getting there. And to name just a few of our milestones, we have a George and Eileen Smith Fund that provides and still provides educational support for our neuroscience staff. We have renovations and teaching facilities on the ward that we've managed with our George and Eileen Smith Fund, special instrumentation for some of our new and innovative surgical procedures. We have a Dan and Bunny Whitney intraoperative MRI now, and that was established almost 10 years ago and has provided us one of the most technically advanced neurosurgical suites in the country. The Reinhard and Elizabeth Muhlenfeld surgical microscope went into one of those intraoperative MRI suites, contributing significantly to its capabilities. The Scott and Brown family's advanced neuroimaging and the Gamma Knife Center, it's now been in operation for almost 4 years. It's turned out to be such a critical component of our new brain center. The Doreen Lutsky Hooper Stroke Rehabilitation Unit, that's located in the K Edmonton Clinic. It's gone a long way toward providing the advanced stroke care that we so wanted to focus on. And the Leona and Ken Biggs and Peter B.R. Allen Neuroscience Intensive Care Unit. That's well into the piloting stages now. It's going to be another key component of our brain center. Let's just start this over again. Okay, this is a picture of our intraoperative MRI. It's located in the main OR in the level 3 of the University Hospital. If you look carefully, you'll see that this unit, which weighs 6 metric tons, it's suspended on a track system from the ceiling. That is some space that you're seeing underneath the machine. Now, I had a young patient some 30 years ago who had a brain hemorrhage. She had a tumor, and we removed the tumor at the time using what we had. It was the old way. And unfortunately, we left a small amount of tumor behind. And many years later, that tumor began to grow, and we waited for the intraoperative MRI unit. She was one of our first cases. She was brought to the operating room, had the skull opened to expose the tumor. And there was a lot of scarring there. It was hard to find the edges of that tumor. We removed what we could see. Then we opened the magnetically sealed and shielded doors. The MRI comes into the operating room with all the metal moved out of the way. And then we are able to image the brain through the open skull. We're able to see if there's any tumor left over. And there was a small amount. We removed that last portion of tumor, repeated the MRI one more time to be sure that it was gone. She's gone on to be a mother twice over and still to this day is tumor free. Now, the next component of our brain center had to involve advanced stroke care. Stroke is just so common. We needed to be able to make progress, like the progress that had been made with heart attacks. Just like the heart, minutes count for the brain. We had to get our patients to the hospital as quickly as possible so that they can have a chance to be maybe remove or dissolve a blood clot, possibly even reverse the stroke. That's where the stroke ambulance comes in. This is an ambulance specifically for stroke patients. It's got its own CT scanner machine inside. That's a Freightliner truck, and that truck and chassis were donated by First Truck here in Edmonton. The ambulance was built from scratch by Demers Ambulance in Quebec, all fully foundation funded. With this ambulance, the patient then in their homes or at the site of the incident, they can be assessed to make sure that they are actually having a stroke and not a seizure or low blood sugar. We want to be able to get the clot dissolving drugs started at the scene. Patient is then brought directly to the brain center at the University Hospital, the correct hospital and the correct time. They might be a candidate for the new interventional neurovascular treatment. That's where the blood clot is removed or extracted, thereby bringing the circulation back to the brain. See if I can start this video. This is a video that shows that procedure. The patient usually bypasses the emergency department directly up to one of two neurovascular interventional suites. The newest one was, again, foundation funded. The small flexible wire is advanced from the leg up into the brain, all the way up into a small blood clot that would be blocking an artery in the brain. The wire then is advanced through the clot to allow a guide catheter to be placed, and that's in preparation for deployment of a stent retriever catheter. That catheter then springs open, springs into action, and it entraps the clot to allow it to be slowly and carefully extracted. And that's where the timing is so critical. If the blood clot is still soft and the brain has not been without oxygen and blood flow for too long, then the damage is sometimes reversible. Dr. Rempel and his team would then see the person start to move their arm and leg and maybe even regain language function while they're still on the angiogram table. For many, it's back to normal life a lot sooner than it would have been. So the next step along our quest for a state-of-the-art brain center and minimally invasive quest would be the radiosurgery program. This would be a device using finely focused radiation beams to treat tumors deep within the brain without having to operate at all. And we toured the world looking at different machines like this CyberKnife with a radiation generator, a robotic arm. The arm was from the automotive industry, and we like this one a lot. But the gold standard was still the Gamma Knife perfection. But even then, there was a problem. As we found out on our travels, there was a new model on the horizon, as it was a real game changer. It's almost like Windows 8 going to Windows 10 overnight. This was going to be a game changer. And we had to go back to the University Hospital Foundation, request additional funding. It was a big ask, but Albertans don't compromise. And I think the phrase "go big or go home" was actually used in that board meeting. So we got the new model, the first Gamma Knife icon in Canada, one of the first in North America. This machine weighs 20 tons because of all the lead lining. And that posed some logistical engineering nightmares when the Gamma Knife was built into the west side of the University Hospital. Inside all of that lead lining is hidden almost 200 pieces of radioactive cobalt. That cobalt is energized right here in Canada, Chalk River, Ontario. Each of these shiny little silver beads emit high energy gamma rays, and 200 of those gamma rays all converge on a target. Each beam is shaped by lead collimators to be able to follow the outlines of almost any size or shape of tumor, some as small as a few millimeters to as large as 4 or 5 centimeters. The head is moved upward and downward, side to side, to be able to treat targets anywhere inside the head. This is an example of what happens to tumors. This would be an acoustic neuroma behind the left ear. And this yellow line is the treatment target, day 1. A year later, we would see the tumor here about the same size, maybe even a little bit swollen, but over the next couple of years, the tumor starts to decrease in size and is fully controlled. And the long-term control rates over the 10 and 20 years are excellent. So we just couldn't imagine how important the Gamma Knife program was going to become for our brain center. We will have treated our 1,000th patient now this week in the Scott and Brown family's Advanced Neuroimaging and Gamma Knife Center. So we have almost all of those key elements of our brain center. We're still working on the neurosciences intensive care unit. Just as lungs and other organs need a general systems ICU and our hearts need a cardiovascular ICU, the brain needs a neuro ICU. That's a specialized unit, dedicated neuro-intensive care physicians, nurses, allied health specialists available around the clock, specializing in brain care. We need timely imaging in our neuro ICU. Ours is going to have its own CT scanner located inside the unit. We need advanced brain monitoring. You can monitor the heart, but there's also ways to monitor brain waves at the bedside day and night. We need guidance systems for hitting targets in the brain. We use them in the operating room and in the emergency room. We need them in the neuro ICU. What a critical component this is going to be for our state-of-the-art neurosciences or brain center. And we're well along the way in the planning and the design process. The University Hospital Complex already has a Mazankowski Heart Center. We have a Ziegler Gastroenterology Center. Ledcor Training Center is in there too. We're soon going to have a new Leona and Ken Biggs and Peter B.R. Allen Neurosciences Intensive Care Unit located in the 5th floor of the University Hospital Walter Mackenzie Health Sciences Center. So our vision of a state-of-the-art brain center is almost complete, except for mentioning one more area that University Hospital Foundation has supported so strongly over the years. That's brain research and innovation funding. This funding is provided for various programs and people in our Neurosciences and Mental Health Institute. We call it NMHI. That's located in many of the buildings and research centers that are attached to the University Hospital. We're excited about our evolving brain center. And again, I appreciate the opportunity to be able to participate in this seminar, tell you about our progress, our dreams, and our vision. We just could not have done this and continue to dream new dreams without the help and inspiration of the University Hospital Foundation, many donors and its supporters. So thanks very much, and I'll turn it back over to the foundation staff and our special guest presenters for the rest of the seminar.
Well, thank you, Dr. Aronyk, and that was amazing. And thank you for all of the work that you did in bringing such remarkable brain care and technology to Edmonton. Our next speaker is Baerach Anderson, a partner at the law firm of Proust Chown LLP here in Edmonton, which for over 60 years have provided sound and practical legal advice. Throughout his career, a portion of Baerach's legal practice has been in the area of estate planning and administration, where he and his team work to provide sophisticated legal and financial planning advice to businesses and individuals. Baerach was called to the Alberta Bar in 2006, and his professional affiliations include membership in the Canadian Bar Association and Indigenous Bar Association. Baerach, I now pass it over to you.
Great, thank you so much. So we're just going to start off here with just my little next slide, I guess, showing me. I just want to start off, of course, with a little more background that I am a parent. I have 2 children, loving children, and a wife. I'm a lawyer, a secondary, family is always first, and I am a partner at the law firm of Proust Chown as introduced. So for me, family does certainly come first, and I'm lucky to have such a great family. And part of family coming first is the planning that goes around supporting your family, and that's the estate planning and the financial planning components. And that carries over into my partners at work as well. So I think what the first thing we're going to do here is we're going to head into an online poll if we can. And so this will help give some information that we would like to get from our audience today with about the will. So the poll is as follows, and if you could please make a selection there. It's when is the last time you reviewed your existing will? And you just have to make one choice. So I don't have a will, within the last 5 years, within the last 10 years, or over 10 years ago. And if you go ahead and answer that now, we'll then compile the results and carry forward.
right, the results are starting to come in. We'll give everyone about 10 more seconds.
All right, so a good amount of feedback here, and it is very standard to what I tend to see when I do ask people about their estate planning. So we can see 23% have answered from respondents that they don't have a will. 47% have responded that they have reviewed it in the last 5 years, which is great to see. 18% responding within the last 10 years, and then 12% saying they last reviewed over 10 years ago. So very interesting, but very typical to what I do see. So thank you for participating. This does give me valued information on how to best sort of deliver some of the materials that I have planned for today. And I will be touching on important times to review your estate planning near the end of the presentation and a little bit throughout. But just to start us off, I do recommend that if you haven't made a plan, you do. And once you do have one, you do review it about every 5 years to ensure that it's reflective of your current life situations. So we're going on here to what are the common documents forming your estate planning. So the primary components to estate planning we're discussing today are going to be a will, an enduring power of attorney, and a personal directive. And typically, these are created, reviewed, and revised simultaneously for efficiency in the time and the cost it takes to get them done. I'm going to speak to each of these individually and separately as we move forward. A topic for another day would be the establishment and use of family trusts in planning as well. So on to the next slide. So we're doing some intro level questions here to get the basics. The first one is, what is a will? Well, a will is a written document which is required to follow a set legislative requirement to be considered legal. And it's to provide a chosen individual to manage your instructions with regards to your assets once you pass away. So the requirements for your will are going to vary from jurisdiction to jurisdiction. And so you want to be sure you meet those requirements where you reside and hold your assets, because that's going to vary from province to province or from country to country. Next slide, please. So what are the types of wills? Well, there's two types of wills in Alberta here that we want to talk about. The one is the standard will, the one everybody probably thinks about, which is typed out, it's dated, and we do have a requirement to be witnessed by two individuals who are not beneficiaries under the will. And so a beneficiary is someone who's going to receive something under the will. We want to make sure your witnesses are not entitled to any gifts underneath your will. Having the witnesses available is important. It does go to ascertain your identity as the person giving the will, if ever called into question, and also to show that there was no duress and that you had capacity when granting your will. So those gifts that you do provide for will be upheld if ever challenged. The second type of will we do see, not too often, is called a holographic will. Now, the requirements for a holographic will are that it is handwritten, it's dated, and it's signed. And so we don't have witnesses on this one here typically, but occasionally it does happen. It's not a recommended practice to use a holographic will. And the reason being is it's often incomplete or incorrect, and therefore it increases the chance of a dispute happening with regards to what your intentions were. Another issue is because it is a signed will with no witnesses, the signature does need to be authenticated. So it doesn't need to be proven from another source. And this sometimes creates issues with trying to track down a signature on file with a banking institution or elsewhere that may not be current to put that forward there. I've personally been involved in several situations where the testator's instructions, that's the person granting the will, have been confusing or contradictory in these holographic wills. And it has created just turmoil for time and for costs for all the parties involved. And it's just something we like to try and avoid if possible. The only time I would suggest ever using a holographic will would be where you don't have a standard will in place and it is an emergency situation. In that situation, it might be advisable to write something down quickly. And so, excuse me, so just as a side note, be very careful when you are writing down anything hastily. I see it or hear about it sometimes, the joke that you can write something down on the napkin. It could be taken as a holographic will and could actually revoke or invalidate some terms you've already planned for. Next slide, please. So who can act as a personal representative in a will? So the personal representative is the title given for the person acting on your behalf. So in Alberta, it is an adult, so 18 plus, and they have to have mental capacity to represent you and act. It is certainly advisable that the person you're appointing be in the same jurisdiction in you. So if you're from Alberta and living here, they're from Alberta as well. And this is to avoid the court requesting or requiring that person to post a bond or security to act on your behalf. We certainly want to keep the parties in the same country, typically just for taxation issues, especially if we're dealing with the United States. You need to ask your personal representative, or should ask them, if they agree to represent you in your will. This will save time and trouble in the event of your passing. We don't want to have to deal with trying to find somebody. So this is why we do encourage you name a primary and then an alternate, or possibly one or two alternates to follow up in case your first person is unable to do it or unwilling to do it at that time frame. So it alleviates that issue right there. Now, that being said, in your will with your appointed parties, if your personal representative cannot act or no one can act in that regard, the will is still valid. So the terms and conditions, the instructions you have there are still valid. We just need someone to step forward and make an application to become the appointed representative on your behalf. Okay. So that would take some extra work. And that's why we say, of course, now going back to our initial poll question, why you want to review your documents every 5 years or so. Key importance here is to make sure your representatives still want to do it or still can do it. Next slide, please. So what does a will do? A will allows you to appoint that personal representative, such as your executor/trustee, to manage your estate. It gives that person, your representative, the authority to work with third parties as required. So the courts, dealing with charities, dealing with your banks, Canada Revenue Agency is a big one, working with your financial and wealth manager with regards to investments, dealing with property you may own, and then of course creditors and debtors. And really important these days is your social media accounts and access to those. So a will is going to set out your wishes and the control to your property. So things such as a specific gift to a charity, such as the University Hospital Foundation, distribution of your residue, which is the funds after payments of gifts and debts. Who is that going to go to? Who do you want to receive the value and benefit of your estate? Establishment of trust conditions on gifts. So typically when we deal with children, you might see distribution based upon age or certain conditions. So a will allows you to set out those parameters there. A will is also very important because it is where you'll make the choice on your election of guardians for minor children as well. Next slide, please. So why is having a will important? Well, as discussed in the previous slide, you get to choose who will represent you and carry out your direction as your personal representative. So I always say I like to think of a will as an instruction manual that your representative must follow and follow the steps within it. So in your will, you do get to control where your assets go and in what order. So by having a will, you provide clarity on your instructions in writing that are required to be followed. So having a will provides for specific charitable gifts again, gifts to chosen beneficiaries. Having a will save time and costs and prevents unnecessary conflicts between the parties. And having a will assists in avoiding future problems as it is a written record and therefore not relying upon what others believe they've been told or may have been told and hold out as your wishes. So it's very clear that this is what you've determined to happen. We're not relying on hearsay and what other people may think you've told them or what they want other people to think that you said. So your will have certain areas, of course, within it, which will typically give a little bit of discretion to your personal representatives. But overall, your personal representative is going to follow your steps and your instructions and carry out your wishes. Otherwise, they face exposure to legal liability and the repercussions for not following your intentions. Next slide, please. So what should be included in my will? Well, most wills that are drafted by a lawyer will include the necessary clauses to allow your personal representative to call in your assets and to pay out your debts. They'll typically provide for decision-making as to income tax elections, dealing with property maintenance, corporate governance, dealing with private held corporations and shares, and again, access to social media accounts and so on. Now, decisions that you're going to add in there will typically be listing gifts to nonprofits, charitable organizations like the UHF again. These charitable gifts, actually, if you're planning for them, can actually provide some tax benefits to your estate. And this is worth a discussion with a financial planner like Richardson Wealth. It allows you to support a cause when you no longer require those funds for your care and support. So that's the big benefit of giving the gifts there in your will. Now you need to remember that simply discussing these items with your loved ones does not bind them or your personal representative or beneficiaries to carry out your wishes. So this is why we do want to include these items in your will and be very specific about what you want to have done. I do suggest you include items of great value or heirloom sentimental value items want to be put in there, and be very specific about who's going to get them, so it can be very easily described and found out. And these are items that you're going to ensure you're going to have for the long term and not dispose of or gift away before you pass. Now, you don't need to list every single little item in your will, and typically you wouldn't want to. The time and cost be prohibitive there. And if you do want to deal with small items, household items, knickknacks, we usually use some sort of rotating choice system, a name in a hat, and following through till the items are all taken as required or wanted. And then the rest, of course, we'll deal with either an estate sale or a donation to a charity of choice. The one thing that is not going to be included in your will, touch on it here, are jointly held assets. So you'll often see with houses or condominiums, you may be on title with a spouse or a sibling and they're held jointly. Jointly means, of course, on the passing of one person, that asset will transfer to the survivor. So it won't actually go through your estate. And then items that have named beneficiaries, any accounts, RSPs, stuff like that won't transfer as well. Those will be outside your will, so we won't account for those in the will. Next slide, please. So what happens when you do not have a will? Well, when you don't have a will, the big thing is no one has provided authority to manage your estate. And therefore, what's going to happen is you're going to have to make a grant to the court. In Alberta, it's the Court of Queen's Bench, for a grant of administration to appoint somebody as your personal representative before they can carry out any actions on your behalf and address your estate and your assets. Without having a will, you haven't directed where anything's going to go. So you're going to be following the Intestate Succession Act of Alberta, which is likely not what you would have chosen for where items will go, because you don't have any set amounts or any direction on the beneficiaries. So there'd be no gifts to charities, no specific gifts of valuables or heirlooms, and you haven't chosen your beneficiaries of your residue as well. So the system that's set out with the Intestate Succession Act basically has a schedule where they start looking at spouses, children, parents, nieces, nephews, and there's a whole web behind that will follow through. So, I mean, in the worst case scenario, it's not that the province gets your money, but it's certainly not going to go where you'd like it to go and benefit who you'd like to benefit from it. Next slide, please. So can you have multiple wills? This question comes up quite a bit, and the answer is yes, but typically you're not going to or not want to have multiple wills, especially when they're dealing with any of the same assets. You would not want to have a same will or a multiple will there. This is why when lawyers are drafting your will, you're typically going to see in there a clause which revokes any past wills or historical wills. That way, it's only the most recent will that would be valid and upheld. So a note to yourself is if you do update your will, replace your will, you want to obtain and destroy any previous versions of the old will so it won't be relied upon. And I would encourage you to, even any copies you've handed out, to also get those back and destroy it, just so there's no confusion and it's just the original will is there. And noting to your personal representative where your original will is held is very important as well. You can sometimes see having multiple wills when you have non-movable assets. So this would be land in a different jurisdiction. So we often see this with vacation homes in another country, and you deal with the asset with a separate will there, and possibly, of course, a different lawyer as well, and working together. And you want to make sure in those scenarios to be very specific as to what asset it is. And we don't want to invalidate one will with the other or revoke the gifts or have both of them fail. So there is some fine tuning to be done with multiple wills. Next up, so second one here, next topic here will be enduring power of attorneys. So this is document number 2. And so an enduring power of attorney appoints a party which is named as an attorney, and it's not a legal attorney, it's a title given to them. And that person is going to act on behalf of you with regards to banking and investments and also land in a situation where you're mentally incapacitated. So this could be a situation where it's a brain injury, it could be a disease such as Alzheimer's or dementia setting in. This is a situation where someone's going to step into your shoes and assist you with these items, so the banking, investment, and land. Next slide is who can be an attorney in an enduring power of attorney. So similar to the will, in Alberta, it is an adult, so 18 plus, and they do have to have mental capacity themselves to act on your behalf. Now, the difference with an appointment for an enduring power of attorney is if the people you appoint to act for you cannot act for you, the document itself is not going to carry the power forward. So we do need to, of course, again, review our documents and make sure the parties appointed are willing to act or still can act for us when we're naming an attorney for an enduring power of attorney. Next slide, please. So what are the types of enduring power of attorney? Well, there's the two primary types here. The first one is an immediate power of attorney, and this is typically used in limited situations. It would typically be coming to effect when it is signed off, but it gives a purpose typically for set events. So maybe a transaction dealing with land while you're away or unavailable out of the country. We typically don't see these too often with estate planning, but sometimes you do. You'll see that power being granted right away to a trusted individual to act on your behalf and make decisions for you. What we see more often is called a springing enduring power of attorney. So it is legal once it is signed off, but the power you've given to your representative is not going to happen until you've actually lost your mental capacity. And the document will put the parameters in there as to how that will come into force. And what we'll typically see is 2 letters from medical practitioners or capacity assessments from those medical practitioners stating that you no longer have capacity. And that'll be used along with the power of attorney to bring it into force and give the power to your representative. Next up. So this is about the third document here we typically see in the estate planning, which is a personal directive. And a personal directive is a document which now appoints an agent. And that's the title of the person in your directive who is going to act on your behalf with regards to personal matters, such as your living accommodations, health and support decisions, and social activities when you become mentally incapacitated. So if we look at the enduring power of attorney we just talked about and the personal directive, I always say it's like the 2 shoes, the left shoe and the right shoe. And when you don't have capacity, somebody's going to step into those shoes and make decisions for you. And that's who we're appointing to do those. So this is a springing document. So it is legal when signed. But again, as we just talked about with the enduring power of attorney when it's springing, it does require those medical practitioners to sign off that you don't have capacity. We do sometimes see with personal directives a change here that maybe one medical practitioner and then your appointed agent who knows you very well who might sign off as well. So there are some small differences we can do with planning on these ones. Next up, so who can be an agent in my personal directive? Flowing through is the theme here from the will, enduring power of attorney, and personal directive. It will be in Alberta and adults, so 18 plus and have mental capacity. And again, once again, if the person is not appointed or you don't appoint somebody, there is no authority provided. I do want to talk right now really quickly that with these 3 documents, a will, enduring power of attorney, and a personal directive, you don't have to have the same people appointed for each one. You can have 3 different people in the roles, and you can have different alternates as well. But you can also have the same person across all 3 if you like. So it's really a personal choice on who you think is going to manage best in these sort of conditions and act for you. That's who you would choose. And then of course, reevaluate when you review your plans. And next up, so why is having an enduring power of attorney and a personal directive important? Well, without the enduring power of attorney, really trying to hit it home here, there is no authority to assist you on financial matters or decision. And without a personal directive, there's no one who can assist you with social care and medical matters or those decisions. So this means that even a spouse, a parent, a sibling, they don't have the legal authority to make decisions on your behalf and help you out. So having these documents does provide that authority, and they can take that and help you with your decisions while you're still alive, but mentally capable of making them all on your own. If you don't have enduring power of attorney and a personal directive and decisions need to be made, what you need is an order from the court, which is going to appoint an individual to become your guardian and your trustee. And this unfortunately takes time. Right now we're seeing 5 to 6 months once the application actually goes in. That's after it's prepared. And the cost of this ends up being in thousands of dollars instead of doing the advanced planning for it as well. Worst case is if no one wants to act for you, then of course you become a ward of the province and it's the public trustee and public guardian who would act on your behalf, or possibly in the interim if no one's appointed as well. So next slide. Who should have a will, an enduring power of attorney, and a personal directive? Well, my answer is everyone. Everyone who's an adult, that is. Children are a different case. Usually if they're pro athletes or famous actors, they may have one. But for most people, you certainly will want to have a will if you have any assets that are not jointly held assets, particularly if you have any investments, if you have bank accounts, and if you have land. We do need some authorities to deal with these assets. The government and the banks, financial institutions aren't going to let you deal with these without having somebody appointed. So it's better to get that jump up and have somebody appointed and have your will and not have to deal with trying to appoint somebody after the fact or someone stepping in. And then if you have minor children, of course, very, very important to have that election as to who's going to be the guardian for those minor children. With enduring power of attorneys and personal directives, anyone who wants to ensure that they have a trusted person appointed to represent them if they become mentally incapacitated. That's who should have an enduring power of attorney and personal directive, so someone can step in and be your champion and take care of your decisions for you. And they would know you best and what you'd like to have done. So again, no appointment means no power. And the worst case scenario is, of course, it is the province or the state who steps in to try and assist you. And of course, they don't know you as well, probably the people you would like to have taken care of you. So next slide. So this ties right back to the poll at the start, is when should you review your estate planning documents? Well, like I said at the start, I would recommend at minimum every 5 years or at a growth stage of your life. So at the start of your career, when you finish school, if you start earning some money, you start acquiring any sort of land, whether it be a house, investment property, getting married, the unfortunate event of getting a divorce, you look at that again, having kids, when your kids become adults, and even when you retire. And so these are all going to factor into sort of your planning and what you're going to do. So at this point in time, part of that review, of course, is talking with your lawyer, but talking with your financial wealth advisors as well, to make sure that you can structure a plan that works for you, that's current and focused going forward. I mean, the best case scenario is you don't need to change anything, and you can just carry on forward with the documents you have, but at least you've taken that look and made sure everything is up to date. I can tell you, and I'm very fortunate, of course, I get to do it a lot easier than most, but I've done my will 5 times based upon the criteria I just told you about. So very important to look at, just make sure they are current and you are well protected for you, and of course for your family and those you care about. So that, next slide here, will be the end of my portion of today's presentation. I would like to thank the University Hospital Foundation, of course, for having me in today to present. And I know we're going to have a question and answer after the next presenter, but of course my contact is there and I welcome questions at any time. So thank you so much.
And thank you, Baerach. And we look forward to hearing from you again. I've noticed a few questions have already come in for you. So you'll hear from Baerach again. Next, I would like to introduce Rob Campbell, who is the Director of Wealth Management and an investment advisor at Richardson Wealth. Rob earned his Bachelor of Commerce with distinction from the University of Alberta in 1993. He articled at Ernst & Young and became a chartered accountant and worked in private enterprise as a CA in the late 1990s before joining the investment management business. Richardson Wealth strives to provide worry-free wealth to the professionals, entrepreneurs, and families that they work with. Through the independent Richardson Wealth platform, they utilize exclusive investment, tax, estate planning, and insurance solutions, all developed around the cornerstone of comprehensive and customized wealth planning. Rob, I turn it over to you.
Thanks so much for the warm introduction, Carolyn. I do appreciate it. And I also have to say I'm honored to be included among such a distinguished group of presenters. So thank you for that. Someone once said that there's only 2 certainties in life, death and taxes. Neither of them are much fun, and I'm going to be speaking about both. Because of that, I'll try to keep it a little light and move through it fairly quickly and leave some time for Q&A at the end as discussed. Next slide, please. Carolyn talked a little bit about our firm, but I'm just going to add a little more knowledge about our firm and our team. So Richardson Wealth is the largest independent wealth management firm in Canada. We are significantly employee owned, which is a big differentiator of our firm. And we bring in open architecture and independence that's allowed our firm to become the first, and I believe still only wealth management firm in Canada, that is, to achieve a fiduciary designation, which means we're never in a conflict of interest position for our clients, and we're very proud of that. Next slide, please. We are located in all the major centers across Canada, and we manage approximately $35 billion in wealth for Canadian households and global households. Next slide, please. My team is Campbell Wealth Management. We're based here out of the Edmonton office. I'll just share a couple of things about our team. One, as Karen mentioned, I'm originally a chartered accountant. I always joke that I still know enough about tax to be dangerous, or at least to ask the right questions. So that sort of tax focus and tax planning is a key element to what we do. The other thing that I would touch on is we really take a holistic approach to wealth management with our clients. And by that, I mean, we look across a client's whole sort of financial landscape at their goals and objectives, financial independence, tax situation, and of course, philanthropic goals, which we'll be talking about today. Next slide, please. What I'm going to cover, I've already talked about our firm and team. I want to go through the tax implications that occur on your death. I want to talk about some tax effective philanthropic strategies for you to consider, and then touch on a few other estate planning considerations to bring it to a close. So let's move on from there. So tax implications on death. Now, before we can talk about estate planning strategies, it's essential to understand a few of the basics that we're dealing with when it comes to tax on your estate. So that's what I'm going to cover off first. Next slide, please. So first and foremost, when you think about a couple, the first thing to be aware of is when the first spouse dies, there's really no issue from a tax perspective. All of your assets roll to the surviving spouse with no tax implications. And so it's quite common for a couple to leave each spouse as their beneficiary. And there's really no tax consequences to that. It's only when assets start to move to the next generation and your beneficiaries that we see tax consequences. Next slide, please. Now, as alluded to earlier, it's really on the second death of a couple that CRA comes to collect their pound of flesh. Now, a few things to be aware of in terms of how that works. So first of all, you will be taxed on capital gains on any securities that you hold. Now, fortunately, capital gains are taxed favorably in Canada. So they come in at a 1/2 inclusion rate. So there is some benefits there around capital gains. But one thing people aren't aware of is those capital gains are applied to public market securities like stock, or capital gains taxes applied to public market securities like stocks in a brokerage account, but it also applies to private company shares. So for example, you might own shares in a family business that have appreciated significantly in value, or many professionals, including I'm sure many of the doctors at the university hospital, operate within professional corporations. The gains in the value of those corporations are all taxed at death. Now, another really key thing to understand is that all of your registered assets come into income in the year of your death, and they're taxed fully at your marginal rate. Now, just for clarity, when I talk about registered assets, I think everyone's pretty familiar with RRSPs. So they're a tax sheltered program to help you save. When you enter retirement or at age 71, the government mandates that you convert your RRSP into a RIF and begin drawing it down over time. So your RRSP becomes a RIF. Your RIF funds your retirement over your golden years, shall we say. But the fact is that when you die or the second spouse dies, the RIF in its entirety comes into income in the year of your death. So that's an important consideration we're going to talk about. Next slide, please. Another thing that's important to be aware of, this is a little bit of tax 101, but it's somewhat misunderstood by Canadians. The way our tax system works is in each calendar year, you start off with your first 49,000 of income here in Alberta being taxed at a fairly low rate. But then as your income goes up in a calendar year, not only are you paying more tax in absolute terms, but you're also paying a higher percentage tax on those higher dollars of income. And as you can see from this slide, that maxes out at 48% of each incremental dollar of income above 315,000. So that's what we mean when we talk about your marginal rate of tax. It's where you fall on that band. Next slide, please. So here's a good example to kind of grasp that. So if you consider an individual with $500,000 in a RIF, for example, if they had no other income, which of course isn't typically the case, usually at minimum one would have old age security and potentially Canada pension plan. But even with no other income, you'd be facing a tax bill of over $205,000 in the year of your death if you die with $500,000 in your RIF or in an RSP. So it's kind of interesting that a lot of people that wouldn't think of themselves as very wealthy in the big picture wind up paying taxes like an NHL player in the year of their death if they haven't done some proper planning. Next slide, please. And then the last thing to be aware of from a tax consideration at death is that life insurance goes tax-free to your estate. So there are some big tax benefits to utilizing insurance as part of your estate plan. And we're going to talk a little bit about that a little further on. So now let's move to the next slide and move into some strategies on how you might minimize that tax or be a little more efficient in supporting your beneficiaries or your philanthropic goals. Next slide, please. The other thing I'll just mention briefly is that I'm going to go through some numbers and some examples here, but it's important to realize with any of the examples I'm going to show and with planning around your estate, the actual results are dependent on your individual circumstances, your income level, your tax situation, and your health. So I would just caution you before implementing any of these strategies that you want to speak with your advisors about your personal situation to see if they're a fit for you. Next slide, please. So the first thing to consider is the benefits of gifting funds while you're alive, whether that be to family or to a charitable organization. Obviously, not only are you around to see the benefit and appreciation of your gifts, but there's some tax advantages to that. So first of all, if you're looking at giving gifts over a number of different years, when you're pulling funds potentially out of your registered accounts or your corporate structure to fund those gifts, you have the opportunity to use those low marginal tax rates from a series of different years. And so as a result, you can potentially save tax while giving those gifts earlier. And I won't speak for the UHF individuals on the call, but I do believe that many charitable organizations as well place a high value in commitment to an ongoing series of gifts over time, and that can certainly benefit you from a tax perspective. As mentioned, that can be good even if giving to family, but it's even more effective if you are donating to a nonprofit because of the donation tax credit that you would have the ability to use to reduce taxes in each of those years. Next slide, please. Strategy number 2 is to think about donating your registered assets to a charity or philanthropic organization at death. Now, of course, this is assuming that you've got other assets, perhaps your principal residence or other securities that are there to support your loved ones. But there can be some significant tax advantages. So in the example I used earlier, if you had a $500,000 RIF and you donated it to a nonprofit like the UHF, you would eliminate that $206,000 tax bill, and the entirety of that $500,000 would go to the UHFs. So this is a way to not only reduce tax, but to do some good in the world if you're in the position to do so. Next slide, please. Now, this slide's a little bit busy, but I want to circle back to capital gains on securities or stocks that you may own. And I'm going to show you an example here where I'm assuming that perhaps you participated in the TELUS new issue years ago when they went public, or maybe you were one of the Albertans lucky enough to invest early in Aurora, one of the well-known cannabis companies here in our neighborhood. But I'm assuming you put $10,000 into a public market stock and it's worth $50,000 today. Now, if you were in a position where you no longer required that $50,000 to live on or to meet your estate needs, one thing you might do is decide to sell it and donate the proceeds to a nonprofit. And that's what you see in the left column. Now, if you sell those securities, you trigger a $40,000 capital gain. Now that capital gain, as I've mentioned, comes in at a 1/2 inclusion rate. And at the highest marginal rate, that results in about $9,600 of tax. That means that if you sold that stock, you could make a $40,400 donation to the charitable organization of your choice. And you would receive, based on that donation, the benefit of a tax credit, which would put about $19,000 back in your pocket. Now, alternatively though, CRA has a unique tax rule where if you donate securities directly to a charitable organization, they will waive the tax on the capital gain. So in the column on the right, rather than selling the stock and donating the proceeds, instead you donate those proceeds with that embedded capital gain in them, which allows you to donate 50,000 rather than the proceeds of 40-odd thousand to the charity of your choice. Now, not only would an organization like the UHF receive $9,600 more, but you also get the enhanced charitable donation tax credit for donating more money, which would mean that your $50,000 donation is only going to cost you about $26,000 after tax. So if you do have securities with large gains or that you've been holding for some time, it's a really great consideration to think about if you're engaging in some philanthropy, how you might be able to do that more tax effectively for both you and the recipient. Next slide, please. All right, so as I mentioned earlier, we're going to look at how you might use insurance to fund a donation at death, given the fact that insurance flows tax-free to your estate. Next slide, please. So we're going to circle back to an example with a couple, a male age 70, a female age 68, that are both non-smokers in good health. Now, if they went out and obtained $500,000 of personal life insurance on a joint and last to die basis, it's going to cost them about $12,000 a year. Now, a couple of things to mention here. So first and foremost, when most of us think about insurance, we think about it from a protection standpoint. Most of us start buying insurance early in our lives when we have a mortgage and young children and loved ones we need to worry about. But because of that tax benefit of insurance, as you age and reach the stage of financial independence, it can become a really powerful tool as part of your estate plan. The second thing I want to talk about is joint and last to die insurance. So what that means is that the insurance policy we're talking about here is on the lives of two individuals, both spouses. Now, there's a couple of reasons for that. As I mentioned earlier, the tax problem doesn't arise for a couple until their second death. So by getting an insurance payout that only pays out on the last to die of the two spouses, it lines up the proceeds with when the tax obligations arise. Secondly, when you insure two individuals on the same policy, it drives down the cost of insurance because, of course, there's a much lower probability of two people passing away rather than one. So let's move on to the next slide, please. So in this example, if that couple had the same $500,000 in RIF assets when the second one of them died, as we looked at earlier, they'd be leaving an estate after tax of about $294,000. However, if they had designated a charitable organization like UHF as the recipient of those insurance proceeds, that $500,000 charitable tax credit is going to completely eliminate the taxes that the RIF would have triggered in the estate. As a result, not only are you in a position where you're enhancing your estate for your beneficiaries from $300,000 to $500,000, but you're also making a very significant donation to the charity of your choice. So insurance can be a really great tool, but of course, we need to look at the cost of that $12,000 a year. So let's move to the next slide, please. So with that couple, age 68 and 70, their life expectancy at that point in their lives is they're expected, according to the actuaries, to live about 23 years. Now, what that means is if they're utilizing other assets or other resources to fund that insurance contract at $12,000 a year, what's interesting is they could instead choose to save and invest that $12,000 to support a charity of their choice when they pass on. Now, the reality is because of the tax benefits of insurance, you would need to invest that $12,000 a year at the equivalent of an 8.5% guaranteed GIC to reach that same $500,000 of proceeds which the insurance provides at death. So it can be really compelling. Now, of course, none of us wants to die earlier, but the other advantage is that if something unforeseen did ever happen to you, the math and the compelling economics of the investment and the insurance policy actually just get better. Next slide, please. So now we're going to switch to a couple of other estate planning considerations that I think are important for you to have on your radar. Next slide, please. So first and foremost, and Baerach touched on it a little bit when he discussed things like an enduring power of attorney, but incapacity prior to death is very common, particularly with things like Alzheimer's, mental incapacity. One thing that is available in the investment world today is you can now name a trusted person on your investment accounts. I can tell you as an investment professional, that can be a very difficult situation if we have a client where we have a sense that perhaps they're not fully cognizant making decisions, or perhaps we're worried that they're under duress, and abuse and fraud is common in our world today. Now, the way the investment business works is your advisor can only speak with you about your investment account, so that can create a difficult situation. But if you name a trusted person, it's someone that you designate that your advisor can contact in the future if they have any concerns about your capacity to make decisions or what's going on with you. So that's relatively new in Canada, and I would suggest you keep it on your radar. Next slide, please. And then second thing to consider is that you want to make all of your philanthropic decisions and estate plans, in my view, in the context of a comprehensive wealth plan. Now, why is that? Well, first and foremost, before you start planning to give all your money away, you want to ensure that you have enough to live on and that your beneficiaries are properly looked after. Secondly, as I alluded to earlier, everyone's tax implications on their estate are going to differ depending on their asset levels, where and how they hold their assets. So these solutions need to be customized to your situation. The third thing I would mention is from the poll question, we saw that 23% of the people gathered with us today don't have wills. Well, I find that a wealth plan is even less common than a will. So I think we can safely assume that there's even fewer of us than that have a comprehensive wealth plan. Yet I view it as an integral tool to properly planning for your estate and also managing through the financial independence phase of your life. We also, through that wealth planning process, have the opportunity to identify and support your beneficiaries and assist you with any philanthropic goals in the most tax efficient manner possible. Now, these are services that our team provides, and we'd be happy to talk to you if you haven't put together a wealth plan. One thing I will point out too, for those of you that aren't necessarily as big a sports fan as me, that little graphic that you see on your screen right now is a football play. I studied at the University of Alberta in my fourth year of business school. I had the opportunity to take a phys ed course, and I chose football. So that's what that is. But as any football coach would tell you, having a clear plan is critical to success. And that is certainly the case when it comes to your estate planning and financial planning. Next slide, please. So just by way of a quick summary, in terms of planning opportunities, consider gifting your funds while you're alive so you can appreciate and enjoy the benefit of those gifts. Remember the tax benefits of charitable donations that you make in your will or in your estate. Consider the benefits of gifting securities with significant embedded capital gains. And don't forget the benefits of considering life insurance around your estate strategy. And then the other considerations is don't forget to consider naming a trusted person on your investment accounts. And lastly, to make your estate decisions in the context of a comprehensive wealth plan. Next slide, please. And just to close, I'd like to thank the UHF for the opportunity to present here today and for everyone's time and attention. And I'd also like to say it's fascinating to me getting to know more about the UHF, because being born and bred and raised and lived my whole life in Edmonton, to me, the university hospital is kind of aligned with every stage of the circle of life. I've spent countless times there, from when I had a nephew with with breathing issues when he was born, to an uncle that struggled through MS, to an aunt that unfortunately had a couple of year bout with brain cancer and underwent multiple surgeries. In that particular instance, not only did we believe and understand that she was getting the best care in the world, but it was also phenomenal how our family spent a lot of time there, and the entire care team, from the surgeons, the oncologists, and even the nurses and other staff that helped out, really almost felt like family. And so I've had firsthand experience of what great work the University Hospital does, and I can't be more proud and appreciative for being able to speak with you here today. So thank you very much.
Nicole, I think you're next.
You bet. Hello. Well, hello, everyone. Thank you, Rob and Baerach, for your enlightening presentations on estate planning. Like everyone here, I'm looking forward to hearing more from you both during our estate planning focused question and answer period. My name is Nicole Germain, as mentioned, and I'm a philanthropy officer here on the development team here at the University Hospital Foundation. And I have the honor of working with many of our donors who choose to include the foundation in their will and to whom we are so grateful for. I'm also the moderator for the Q&A today. And as mentioned earlier, we have a Q&A box at the bottom of your screen. So please submit any estate planning questions you have for Rob and Baerach here. We've already had quite a few questions come in, so thanks so much. So we'll start with some of those while we wait for a few more questions to come in. And we're going to do our best to get through as many of your questions as possible in the time we have left today. So I'm going to keep us on time. So our first question is, Baerach, we've heard lots of great info in getting started in the creation of a will. What could someone expect it may cost to get started, and what's the first step they need to take?
Sure. So a typical first step, is reaching out to your professional. So it's going to be finding a lawyer you're comfortable with, and then also, as Rob had mentioned, working with your wealth advisor. So a lot of times the wealth advisor is going to put together a lot of the information the lawyer will actually need. So that might actually be the first step there, and then pass it on over. Most lawyers, I know we do this, we'll either have an in-person meeting or we'll have an actual questionnaire that we have you complete to gather the information we want, so we can start drafting for you and creating an initial draft that we then would review and fine tune to make sure we're meeting all your requirements and flagging or identifying things you may want to think about. So that's sort of the first steps. And the next step, of course, after that is like second draft, meet to sign it. Now, that can be done virtual, it can be done in person. Of course, COVID has changed things. As we see, we can actually sign virtually as well these days. And from a cost perspective, it is going to vary depending on what you need to get done. So if we're doing elaborate trusts, insurance trusts, spousal trusts, these are sort of outside the box. We need to discuss it. But if you're dealing in a situation where a lot of times it is let's call it the old-fashioned nuclear family with a couple and they have a couple children, we're typically looking for a full package of the will, enduring power of attorney, and the personal directive. You're looking at about $1,200 is sort of that range that you would typically see to get that whole process done.
Awesome. I'm not sure, Rob, if you want to comment as well on that.
Yeah, I'll chime in on that too. Just one of the benefits of the comprehensive wealth plan, in our experience, one of the reasons a lot of our clients hesitate getting their wills done or updated is because it can be a bit of work gathering that information. It's not always the cost that's the bottleneck. It's just having to gather information. And one of the benefits of doing one of those wealth plans is we really work with our clients to compile a lot of that information and put it in a format so that when you do sit down with a legal firm like Proust Chown, you can have that process happen efficiently and smoothly. And so it kind of really dovetails nicely, both pieces to that.
Excellent. Thank you. Baerach, can you tell us a little bit more about what probate means in relation to your estate?
Sure. And so probate's that one word that people hear a lot and maybe don't know exactly what it is. So probate is the court approving the validity of your will and the parties who are appointed to act on your behalf. So probate is typically going to be required when you have land or when you have financial investments, because you're going to need the court to approve the will and the parties before you can act, because those institutions are going to want to see they're dealing with the appropriate party from their liability perspective. So it is that application to the court to approve and vet the will.
Okay, excellent. Rob, we have a question about RIFs. Should I liquidate all my RIFs while I have mental capacity, and or should I give it to my grandchildren?
There's no quick and dirty answer to that, but I would suggest it's worthwhile thinking about doing some of that gifting, assuming you're not going to need your RIF to finance the rest of your life. The benefit of doing it over time, as mentioned earlier, is if rather than leaving it all to the end in your will where it's all taxed in one year, if you make regular withdrawals each year and do some gifting each year, you're going to pay less tax typically on those withdrawals. Now, in order to kind of finalize that decision, we need to talk a little bit about your income situation and where you're at. But certainly, I think it sounds like it's worthwhile to look at that type of strategy and how that might be tailored in this particular circumstance.
Okay, awesome. Now, here's a question, Baerach, for you. Can you specify certain people who you do not want to receive anything from your estate? And can this avoid having someone contest your will? I thought that was a good question.
Well, I've never put in any of the drafting that I've done that excludes somebody. The will typically is putting your instructions in as to who you'd like to receive it. So long as you're not excluding a party that would be entitled to something, so let's say be a spouse or a dependent child or minor children, there typically should not be a claim from those parties. So as long as you don't have an obligation to support them and care for them after you're gone, you don't have to worry about specifically excluding people out of your will.
Okay, good to know. Rob, and we have a question about TFSAs. What happens to a TFSA at death?
So a TFSA, unlike your RSP, so a TFSA is like an RSP in that it grows tax sheltered and it is a registered plan. But unlike your RSP contributions over the course of your life, which are tax deductible to you, your TFSA contributions are not deductible. As a result, which CRA has chosen to do, is not tax the TFSA on withdrawals, unlike your RSP. So whether you withdraw from your TFSA while alive or you leave your TFSA to your estate, there's no tax consequences to the TFSA. So yeah, it's much friendlier from a tax perspective than the RSP. So you don't need to worry about the TFSA being taxed in your estate.
Okay. Baerach, we have a question about power of attorneys. Can you have two enduring power of attorneys, say two sisters or a sister and a daughter?
Okay, so if you have two people acting together, is the question as your appointed party? Yes, you can. You can certainly have two people acting together. We'll often see requirements, whether it just be they're joint, they have to agree on decisions, which can be troublesome, or they can be joint and individually named. So they both have the power, but they can decide individually on what decisions need to be made. So, but you can have two parties acting together, yes.
Okay.
Baerach, one thing I believe I've heard before is that often it can be advisable to have one or three people so that you don't have two people disagreeing and having a stalemate situation. Is that accurate, or am I off base in raising that question?
No, you're not off base. And I mean, that's typically like, so if we are going to appoint two parties, we typically would have the joint and individually. So the person who makes that decision and decision is affected, you're following that. But my practice is typically to have the one person act. That person who's acting can always have people help them out. But of course, you get in that situation where we have two and there is a disagreement. I mean, to add a third person in, it becomes a little bit like herding cats at times, Rob. So we typically try to avoid the less people you can, the better. And if you're dealing with, children or siblings to help you out, having some controls in their mechanisms to make sure that once that first decision is made, that's going to be the binding one, and we don't need both people to agree on the decisions.
Makes sense.
Okay, Baerach, another question about wills. Can a person have one personal will for personal assets and a separate corporate will for corporate assets? And can they be managed by, say, adult children and by other professionals if it's your corporate?
You typically wouldn't see a situation to deal with that sort of scenario. What you could have, I think what might be used would be a special trust within the will to deal with the corporate assets and have who you want to have appointed there. But typically we wouldn't see, especially in the same jurisdiction, you typically wouldn't see your assets being divided into two separate wills. But we can do something with probably some specialized trust or trust wordings to deal with that.
Okay. Awesome. Now, one of our participants, Rob, has a question for you. Baerach had touched on a little bit about the rough figures, what it may cost to have a will. Can you comment on what someone might expect a wealth plan could cost to put together?
Yes and no. So I'll talk about how our team handles it. We typically, generally speaking, for us, the wealth management component of our practice is what drives the bus for us. And so our clients pay us based on their assets under management that we're managing for them. And then part and parcel with that service comes all of the planning work that our firm does. So we typically don't do separate billing for wealth plans. Now that said, I do believe we have the ability to do fee-for-service planning for particular individuals. I don't know the exact numbers off the top of my head, but I'm going to suspect it would probably start in the $1,000 to $1,500 range for a one-off wealth plan. But of course, if the person that sent that question wanted to get in touch with me, I'd be happy to find out more details about that if they were interested, and could certainly clarify that. But I would assume you're probably looking in a similar price range to a will to get started.
Okay.
Depending on complexity, of course,
okay,
as Baerach would suggest with the will.
Perfect. Baerach, what about in the case of separation or divorce? How would that affect a will, and what would a couple need to do?
So once the divorce is finalized, the act is actually caught up years ago now. So your divorced spouse is actually not entitled to your will. So if you forget to change your will, you're great. You're covered off there. This sort of goes back to the question you asked before about excluding somebody, I think. And this is actually ties in nicely, because what we'll often see now is if there is a separation agreement or a support agreement in there, we will sometimes refer to that in the actual will. So it is known as to what that agreement was, when it was granted, and what it provides for. So we can address for the fact that that spouse may not be entitled underneath the will to more than what they should be, or specific gifts, insurance. But we can address that in the will.
Okay. Rob, one of our participants has asked about donor advised funds. Can you tell us about how that may be beneficial to someone who is in their estate planning process?
You bet. So donor advised funds are a little bit unique, and they come into play when you want to make a gift. However, you're not ready to sort of fully relinquish control of the funds, or they can also be very effective if your goal is to set up an endowment type series of gifts over time. And so what you can do is you can donate your money into a donor advised fund where you retain control of the money that you donate to that. Now, the benefit of that from a tax perspective is you get all the tax benefits of donating the money in the year that you do it, but you continue to control the funds and can then administer gifts from that donor advised fund over time. And you also have the latitude to change the recipients of those gifts. So it gives you a little more flexibility going forward if you perhaps wanted to make a commitment, but wanted to leave yourself some flexibility in case you thought you might change your mind down the road. But certainly there's some big tax advantages for that. And it can be particularly useful if you were for some reason in a significant tax year. If you received a big bonus, if you sold a business, sold some land where there are tax implications, that could be worthwhile considering to offset some of that income in a particular year. But they're quite a unique tool, but it maintains a lot of flexibility while still getting the tax advantages of donating funds, if that makes sense.
Excellent. Well, I'm gonna leave us with one final question because I'm conscious of our time, but I think we've squeezed in lots of great questions. This could go to either of you likely. So from a power of attorney perspective, are they allowed to gift on behalf of the senior to a charitable organization? So what's within their rights?
Go ahead, Baerach.
So the power of attorney, if you want to be sure you want to continue on gifting, and these are, you want to continue gifting on an annual basis or semi-annual basis, you would specifically put a term in there to allow that to happen. I mean, otherwise, standard wording in most power of attorneys will allow for regular gifting. So if you have been given, let's say if you're giving sort of a regular donation of, a monthly donation of $20 or $100, or you give an annual donation of $2,000, you can continue to do that. There shouldn't be any issue with that. But if you want to allow for it specifically, and maybe in more discretion or larger amounts, you would probably want some specific drafting to do it.
Okay. Excellent. Well, thank you both so much for your time today. I think those questions were fantastic. I'm now going to turn it back over to my colleague Carolyn to wrap us up. So thank you.
All righty.
Thank
Well,
you so much, Nicole.
Thanks.
And thank you, Nicole and Baerach and Rob, and thank you to our audience for submitting those great questions. I certainly learned a lot. On behalf of the University Hospital Foundation, including Lisa, Nicole, Emily, myself, and of course, our very special guests, Cathy Housdorff, Dr. Keith Aronyk, Baerach Anderson, and Rob Campbell. Thank you so very much for your time and active participation. We hope you all found today's session informative, and within the next few days, we will send you a short survey and you can let us know how we did. We will also be sending you the recording from today's virtual seminar, and certainly we invite you to share that with friends and family members. And if you would like to learn more about us, please reach out by email or visit our website at give2uhf.ca. You can also watch recordings from other virtual events on the University Hospital Foundation's YouTube channel. And we are excited to share with you, we have yet another virtual event planned for Thursday, November 4th, which will be on kidney care and which is this year's Festival of Trees cause. And we hope you will tune in. So today we have learned how including a gift in your will can have incredible tax benefits and also have major impact on organizations like the University Hospital Foundation. Planned gifts ensure that innovators like Dr. Aronyk will have the means to pursue breakthroughs, advance patient care, and transform health in our community. I am proud to share that over the last 10 years, thanks to these gifts, $22 million have been reinvested back into advancement of healthcare technology, equipment, and research. Now that's pretty amazing impact by our plan giving donors. So thank you so much for joining us today. This includes our formal presentation, but I do leave you with a 1-minute video entitled Ignite 2030. Thanks so much, everyone. Have a great evening.